Hi, and welcome back. Today I have an order to show cause, once again by Judge Jeffrey A. Cohen, and I want to compare it to like Braveheart's revocation, because this case is very similar to Braveheart's. Now, this individual's permit was not revoked, and for good cause. Once again, this is like to show you how arbitrary discretion works and how unfair it is. Once again, you go to the county clerk's office, land records, most helpful people on the face of the earth. They'll bend over backwards for you. I can't thank them enough. Okay, I'm going to go over the pertinent stuff that's in this order, because it's very lengthy actually. And I'm just going to get to the essentials and do a comparison between this individual's, which we'll call Mr. D, and Braveheart's. Okay, and it's dated October 8th, 2008. This affirmation is made upon personal knowledge and information and belief, the sources of which are counsel's investigation, materials previously disclosed and provided by the Westchester DA's office, court papers filed by the Westchester County Attorney's Office in this proceeding, and all of those records and materials constituting counsel's file herein. By application dated May 2nd, 2005, respondent applied for a pistol license for the stated purpose of target shooting. Thereafter, following the necessary and appropriate, of course, background and investigation and criminal history review, Westchester County Court Judge Lester B. Adler issued respondent pistol permit number. The respondent registered a 9mm pistol, and then he purchased another pistol. And on or about July 23rd of 2008, respondent was served with an instant order to show cause requiring him to surrender his pistol permit and revolver to the Westchester County Department of Public Safety, pending the county attorney's application to revoke respondent's pistol permit due to respondent's arrest for an assault in the third degree, a Class A misdemeanor in violation of Penal Law Section 120 on June 24th of 2008. In accordance with the court's order, respondent surrendered his weapons and pistol permit to the Larchmont PD the same day, June 24th, 2008. Now, as you recall from the previous video, or if you haven't seen the previous video, it's actually the initial one, I believe, Braveheart voluntarily surrendered his permit the same day he got the same notice. So it's the same thing. He voluntarily went down, surrendered what they wanted, the pistol permit, and same exact thing. Okay, then on June 24th of 2008, respondent voluntarily surrendered to Larchmont Police Department when he learned that he had been named in an alleged assault that took place at Palmer's Crossing in the village of Larchmont. The alleged assault took place on March 9, 2008 at approximately 1:30 a.m. during a melee at Palmer's. It should be noted that as many as 10 people could have been involved in the alleged assault, and furthermore, eyewitness testimony was unclear, conflicting, and unreliable with respect to the number of people involved, as well as the identities and respective roles. While the respondent was present at Palmer's Crossing on March 9, 2008, he was not involved in the incident. Accordingly, respondent retained private counsel, which Braveheart did not, because the Westchester County Attorney at the time, George Mancuso, who no longer works for the county, told Braveheart that he didn't need to hire counsel because unless he was facing a felony conviction, they couldn't revoke his permit. And it goes on to say, like I said, this individual retained private counsel. He voluntarily surrendered and entered a not guilty plea. At all times during these proceedings, respondent maintained his innocence. In fact, respondent was so adamant about his innocence that he instructed our office to reject a plea offer from the Westchester DA's office, which would have reduced the misdemeanor charge of assault third degree to disorderly conduct, a non-criminal charge. Now, Braveheart also professed his innocence, and he pleaded not guilty, and was ultimately his charges were ultimately dismissed. And it goes on to say, once again, despite being wrongfully arrested for a crime he did not commit throughout the course of respondent's arrest, he was cooperative in all respects with investigation and arresting officers. His behavior in this regard speaks volumes of respondent's good moral character and respects for the law. Additionally, the respondent surrendered his 2 guns and permit to the Larchmont PD You know, when Braveheart was arrested, they came here with 6 local PD officials, 2 people from LA, K9 unit. The only thing that was missing was SWAT and a helicopter. I mean, it was ridiculous. And he also cooperated 110%. Had Judge Jeffrey Cohen looked into the matter, he would have saw just how much that Braveheart cooperated. And as a matter of fact, you know, Braveheart wrote Judge Cohen, what, about a dozen times? A dozen times, approximately. And out of all those letters and the request to have an order to have a sit-down, Judge Cohen may have answered maybe a couple of questions and absolutely refused to have a sit-down. In my opinion, that's behavior of someone that's cornered and really can't really get out of the corner. What are you going to do? You know, rather than answer questions or rather than have a sit-down, you just refuse. Arbitrary discretion. This is how it works, people. Some people get away with it, some people don't. Depends how the judge feels. If he, on that day, if he's biased or she's biased or prejudiced or has favoritism or whatever, it's all toss of the dice. That's how arbitrary discretion works. Subsequently, on August 19, 2008, application was made and granted to the court for an adjournment and contemplation of dismissal, what's called an ACD, an adjournment and contemplation of dismissal. Braveheart was totally acquitted of his charge, and charges were dismissed and the file and records sealed. Okay, then it goes on to say, it goes on to say, respondent is a 30-year-old lifelong resident of Westchester County. He has absolutely no criminal record, is gainfully employed, and is a member in good standing of local union. As indicated above, respondent adamantly denied his involvement of any assault, and the criminal charges against him are soon to be dismissed by operation of law. Now, Braveheart at the time was 43 years old, approximately, and also a lifelong resident of the county of Westchester, pays enormous amount of money in property taxes, has a good job, no criminal record whatsoever, no drugs, no alcohol abuse of any kind, doesn't even drink. And of course, Braveheart maintained his innocence from day one. In determining whether to revoke a pistol permit, a judge is vested with broad discretion to resolve factual and credibility issues, and her determination is accorded great weight. Case law. Then it goes on to say, it is respectfully urged that the facts attendant to respondent's arrest do not support revocation of his pistol permit. In fact, the final disposition of the charges lodged against the defendant, an ACD, demands that respondent not be penalized in any way based upon his arrest. Nothing contained in this record tends to show that respondent lacks the good moral character required for gun ownership. To the contrary, the respondent cooperated fully with the police in their investigation. No allegation has been made that respondent was difficult or threatening. Same thing with Braveheart. The police never said that he was aggressive, non-cooperated. I mean, when he was arrested, he was actually sitting in the front seat. Was it the front seat? I don't know. He might have been front seat or back seat, whatever. But he wasn't handcuffed, and he cooperated 110%. Respondent was not armed at the time of his arrest, nor was Braveheart armed at time of arrest. He has never been accused of irresponsible gun ownership. Neither was Braveheart. Braveheart was never accused of irresponsible gun ownership. Moreover, respondent's exemplary personal and professional life is far more indicative of his moral character and standing. Well, had Judge Braveheart and Judge Casey, of course, because basically Judge Cohen basically carbon copied what Judge Susan Casey gave as her reason for revoking the permit. So basically, Judge Cohen, what Susan Casey wrote, Judge Cohen went with in denying Braveheart when he reapplied. Arbitrary discretion. This is how it works. Well, unfortunately here on YouTube, time is very short. You can only give me 10 minutes here at a clip. I got some more interesting cases coming up. Stay tuned. God bless. and support the NRA.